Good. That's good.
Welcome, friends, to Innocent Until Proven Guilty, when employment law becomes criminal. This is the Hampton Roads Chamber and HRSHRM, a presentation for this month. Thank you for switching to virtual with us. We do miss getting all together, but this is the next best thing, right? We can still come together virtually. We are always thankful to our sponsors of these events. Our series presenting sponsor is South Bay Communications and Security. And with us to make some comments, we have series presenting sponsor Michelle Ward, who's the Manager of Business Development. Michelle?
Hi, good morning. My name is Michelle Ward, as she said, with South Bay Communications and Security in Chesapeake. We design, install, maintain, and support locally your communications and electronic solutions from beginning to end. And that may include anywhere from card access to intrusion, structured cabling, cameras, video surveillance, and business telephones. I believe our clients like working with us because we have a great partnership and we believe in a lifetime relationship with our clients. We also understand the trust and confidence they have placed in us, so we value that as well. Just during this season of difficulty, a lot of times we have some nonprofit clients that we support. We have been very blessed here at South Bay. In the last couple of months, we've been able to support the For Kids, Her Shelter, Tidewater Pregnancy Center, CareNet Peninsula, EquiKids, Virginia Beach SPCA, Norfolk SPCA, and the We Promise Foundation. And that's just a couple that that I could think off the top of my head that were recently supporting them. So we challenge other businesses if they are also blessed to continue to support their nonprofits. We are proud to be a sponsor today of the Human Resources for Business Leaders when employment law becomes criminal. South Bay does believe in connecting and protecting your business with today's technology, and we do believe that that's more important than ever today. And we thank you. We look forward to the presentation today.
Thank you, Michelle, and thank you for all you're doing, and thank you for the reminder to all of us to support our nonprofits. And I think every nonprofit that you mentioned is a member of the chamber, and so we're thrilled too. So thank you very much for all your.
Yeah, we just feel like we want to support. We believe we're blessed now, and you should really concentrate on trying to spread that blessings to others.
Yeah. Wonderful, wonderful. Michelle, thank you. And thank you again for your sponsorship and all that you're doing to keep all of our businesses safe. So thank you. Our other sponsor today is Dream Vacations. I think we all could use a Dream Vacation right about now. Take their email and let's all just go. But anyway, so thank you to Dream Vacations for giving us something to dream about as we go through this craziness that we're going through. I'm now going to introduce our keynote speaker today. Our keynote speaker is Melina Radovic. I think Leanna has a different slide to put up here. Melina is an attorney in the Norfolk office of Jackson Lewis. Her practice focuses exclusively on employment litigation, workplace training, and client counseling. Melina defends employers against claims brought under Title VII, ADA, ADEA, and FMLA. She also provides clients with employee handbook review and training on a wide variety of employment topics. And as we're all going through these changes in the world, and we were beforehand talking about changes in the workplace and virtual and where the barriers are and all that, I think everybody is reworking their workplace manual right now. So you can reach out to Melina for some help with that. Prior to joining Jackson Lewis, Melina was an assistant Commonwealth attorney in the office of the Norfolk Commonwealth Attorney, where she successfully prosecuted hundreds of adult offenders for felonies, misdemeanors, and probation violations. And she now uses her prosecution experience to defend management charged with criminal offenses stemming from workplace incidents. Her bio goes on and on, but I will let you all Google her so that you can get the full picture. But most important, we want to hear from Melina Radovic today. And so Melina, I turn everything over to you.
Thank you, Priscilla. Hi, everyone. Feel free to call me Mila. It's a lot easier. I am so happy to be here today. This presentation may seem a little weird and out of context, given that a lot of companies are working remotely. However, these are principles you want to keep in mind as your employees do return to work. And some of these incidences can also arise when you have employees working remotely. So I'll talk about more about that as I go through the presentation. Perfect. So this presentation really stems from the, oh, my screen is frozen for a second. Give me 1 second. Okay. Okay, there we go. This presentation really stems from the rise of the Me Too movement. Most of you are probably very familiar with the Me Too movement. Ever since it started in October 2017, it has drastically changed the way that a lot of employers handle sexual harassment claims in the workplace. And although this movement has been around dating back to maybe the early 2000s, it really gained a lot of popularity when Alyssa Milano tweeted out in 2017, "If you've been sexually harassed or assaulted, write me too," as a reply to this tweet. The initial tweet talked about sexual harassment and sexual assault. And although those are two terms that a lot of people use interchangeably, they actually have very distinct meanings. And as you'll see during this presentation, they can have very different legal repercussions for employers. And in response to her tweet, we saw a lot of celebrities and public figures tweeting out "Me Too" and talking about their own experiences. And a lot of those experiences were heavily focused on incidences that occurred in the workplace. This spurred not just celebrities talking out about their own experiences. We saw a drastic increase in the number of tweets and social media posts on Instagram and Facebook talking about everyday people's experiences with sexual harassment and sexual assault. Sexual harassment is something that is a term most associated with workplaces. We also do see it in the education setting for students, but sexual harassment is more so a term of art when it comes to employment. Sexual assault is more of a global term that we see in everyday context. You don't necessarily have to know the person who's committing a sexual assault, whereas with sexual harassment, it tends to be either a coworker or a classmate. And so in response to the Me Too movement, we saw a group of celebrities band together and create the Time's Up movement. And the purpose of the Time's Up movement is really to end the silence that was associated with sexual harassment and sexual assault in the workplace. A portion of it provides funds for victims of sexual harassment and sexual assault to seek out representation. Time's Up initially was very much concentrated in specific industries of low wage earners, thinking about the hotel industry, thinking about women who work in agriculture. People who typically make very little money would not necessarily have the funds to afford an attorney to pursue their claims. And in the criminal justice system and just the justice system in general, we do see something called the justice gap, where if you don't have the means to pursue your case, you're either not going to pursue it or you're more likely to lose in a lawsuit down the road. And so they have provided a lot of funding. Interestingly, not only have they done this, provided a lot of funding for victims of sexual harassment and sexual assault, we actually did see a rise in the number of sexual harassment claims that were brought to the EOC from fiscal year 2017 to fiscal year 2018. It was actually a 13.8% increase, and that's astronomical. The amount of claims that were being filed now was just exponentially more. Last year, from fiscal year 2018 to fiscal year 2019, the EOC, although they saw a decrease in the number of EOC charges that were filed with sexual harassment, they had a record-breaking year when it came to the number of settlement payouts for sexual harassment. It was a 12 million increase in comparison to the year before. And so as a result of that, sexual harassment is now again being talked about a lot more. We saw a small lull after the initial Time's Up movement, and last year's numbers, when they came out, it just reinforces the importance of addressing these issues in the workplace, because it can have serious repercussions. A lot of companies, you know, Me Too happened. Hey, we're going to do some training. We're going to update our employee handbook, and that's it. We're done. We're not going to talk about this again. We've done everything we can, and that's not enough. You have to keep training on these topics. You have to make sure that your employees are getting updated copies of your employee handbooks, and that you are constantly talking about what your company, the policies and procedures it has in place for sexual harassment. Otherwise, you're going to have an issue if a lawsuit does arise. And I'll get more into that as we go down the presentation. So obviously everyone is very familiar with, there's been an increase in EOC charges and lawsuits stemming from sexual harassment. The thing that most employers are not aware of, though, is that we also saw, at least in the Commonwealth of Virginia, a drastic increase in the number of criminal cases where a victim was pursuing criminal charges against a coworker or a supervisor slash manager for forced sexual crimes. And between that very same time period, from 2018 to 2019, there was I believe it was like 30% increase in the number of cases where the accused was either a coworker or an employer. That could be the owner of the company, it could be a supervisor or manager. And so that, you may be thinking, well, that's just an employee committed an act against another employee. I have nothing to do with that. Why should we be concerned about it? And the reality is that can have serious civil liability on your end. And most employers, until they've been in that situation, aren't aware of that they could be held legally liable for the actions of one of their employees, even though they didn't condone it, they don't ratify it. And so that's really what this presentation stems from. Over the last few years, I have, in my own practice, I have seen a lot more of these cases. It may, in years prior to the Me Too movement, from talking to other attorneys at Jackson Lewis, sometimes you'd see this, I don't know, once every 3 years. You would have a client call you and say, hey, I had a supervisor accused of assault. Can you guys help? And Jackson Lewis does have attorneys who handle this, including myself. And that's really what it would be. It'd be once every few years. Now, in the last 3 years, we're getting calls for this all the time. This year alone, I've had three clients have to face this, or faced with this issue. And we handle the criminal aspect of it, but then we also handle the long-term civil aspect of it. And so in dealing with these cases over the last few years, I have developed this presentation that puts you in the place of a company where you have an employee accusing another employee of sexual assault offenses. And so this presentation has kind of taken several real life scenarios and combined them into one, and gives you an idea of the process that you would go through if you had an employee accused of a sexual assault crime, and how that would affect the company long term. So this fact pattern is called Commonwealth v. Matthew Manager. Kind of borrowing from Law and Order. A lot of people see it as, like, if you think about Law and Order SVU, you always see the case that says State of New York versus defendant's name. Virginia is a Commonwealth. We're not actually a state. That's a difference without a distinction that doesn't really matter, but that's how cases are captioned in Virginia. So let's go into the fact pattern. Oops, I went one too many slides. Hey, Leanna, do you mind, my controls have disappeared. Do you mind going back?
Yep, absolutely.
Sorry.
No, you're okay. Give me just 1 second.
Oh, they're back.
Got
Okay. Yes.
it? Okay.
Okay. Okay. So it is December 30th, 2019. We've built a time machine. It is pre-COVID. You are faced with a scenario where you had a manager, his name is Matthew, who has been accused of sexual assault and sexual harassment that stems from a workplace holiday party. And I assume no one is going to be having holiday parties this year. But next year, if the restrictions are loosened, this is definitely something you might want to think about as you plan your workplace holiday parties. So it is December 30th. Your manager, Matthew, is not in the office that day. Around 2:30, deputies from the Norfolk Commonwealth Attorney's Office come to the office asking to speak to Matthew. You, as the HR person, tell them that Matthew's out of town for a client meeting. The deputy responds that Matthew has warrants for his arrest and that he needs to come down to the police operations center to turn himself in. After the deputies leave, you immediately call the president of the company to explain what happened. Together, you agree to call Matthew, but Matthew does not pick up. And I swear, in my personal experience, every time this happens, the employee's not there. And the first person to find out about it is either HR or a manager or someone in the company. And you're never able to get a hold of the employee that's been accused. So that's very common in my experience. So the following, on January 2nd, fast forward a couple of days, Matthew comes to your office and says he wants to discuss something that happened after the holiday party on December 20th, 2019. You ask if this had something to do with the deputies from the Norfolk Sheriff's Office that came to the office on Friday, and if it's true that he has warrants out for his arrest. Matthew says that he was arrested on December 31st and charged with indecent exposure, public masturbation, assault and battery, and sexual battery. He then hands you a copy of the criminal complaint, which was filed by Emily employee. So at this point in time, here's your cast of characters. It's you, the HR investigator. You have Matthew, manager, who's been accused of sexual assault, indecent exposure, public masturbation, and assault and battery. You have Patricia, president, who's the president of the company, and now you have Emily, employee. Emily was an account specialist who abruptly quit without any notice on December 23rd, the Monday prior to the police coming to the office. I'm sorry, the sheriff's deputies coming to the office. When everyone came into the office on Monday, you found that her office had been cleaned. She left no note or explanation for her sudden departure. So now you have to come up with an investigation into the allegations against Matthew, manager. And a lot of companies might, at this point in time, think, well, why do I need to investigate this? The police are investigating it. How does this affect me? And that's kind of the wrong mindset to have. As an employer, you have an affirmative duty, especially if you are subject to Title VII, to investigate accusations of sexual harassment or sexual misconduct in the workplace. And so once you receive this type of allegation, it's important to promptly start an investigation and do it competently, effectively. And if you don't, that can have legal repercussions against you. And those legal repercussions I'll get more into at the very end of the presentation, but this is something that's very important to keep. Okay, so this is a copy of the criminal complaint that you would have in your investigation file. It's the document that Matthew gave to you that Emily filed. with the magistrate's office. And so it's very important to keep this in mind. This is a misdemeanor criminal complaint. And that's very important. And I'll talk more about why it's important that's a misdemeanor versus a felony as we get through the fact pattern. So this is what a misdemeanor criminal complaint looks like. It has an explanation of the facts that the victim is alleging. It has the name of the person who's accused, and a guesstimate really about their race, their sex, their height, and their weight. These are actually really funny to read when you're a prosecutor because you're expecting to have someone come into the courtroom that resembles this. And sometimes people would like give someone an extra 100 pounds or 200 pounds, and it's the furthest thing from what you're expecting. So this is really what a criminal complaint looks like for a misdemeanor. We're going to get into the facts of it right now. So Emily has alleged that on Friday, December 20th, so this is 1 week before the sheriff's deputies come to your office, that she was employed as a count specialist at Safeway Financials, which is the company that you are an HR investigator for. Well, you're in HR, you work in HR, you're doing the investigation for this case file. And so on that date, she was working on a very important pitch for a potential new client with Matthew Manager. The company that day was closing early for their annual Christmas party. The company usually closes around 1 p.m. for a late lunch, followed by a party at Bad Decisions Bar. That morning, Matthew suggests that Emily and he skip the office lunch and continue working on their presentation so they wouldn't have to come in over the weekend. Matthew had promised his daughter that he would help work on her costume for the school's holiday pageant. Matthew says that we could join our colleagues at the holiday party and then come back to the office afterwards so that we could finish our presentation. Around 5 p.m., Matthew and Emily, I think it skipped a slide. Oh, okay. Around 5 p.m., Matthew and Emily go to Bad Decisions Bar. After they skipped the holiday lunch, they decide to only drink 1 beer. 30 minutes into the holiday party, Emily looks over at Matthew, who was already on his second beer. Around 6:30 p.m., Emily goes over to Matthew and asks him what time he wanted to go back to the office. He said that they should probably leave around 7:30, and that it would probably take us a couple of hours to finish up. By that point in time, Matthew was finishing his third beer and starting his fourth beer. Around 7:15 p.m., Emily says that she approaches Matthew and says that we should head out soon. Matthew says that he wants to finish his last beer. Patricia, president, turns to Matthew and says, "No, stay for another beer." Emily tells Matthew that she's going to head back to the office and that he could join her when he finished his last beer. Obviously, that's not something that presidents of companies should do, but that's what happened according to Emily. Around 7:45, Matthew comes back to the office. He was clearly intoxicated, is what Emily puts in her criminal complaint. So Emily suggests that they order a pizza, put on some coffee, and then go back to work. Matthew was in no condition to drive home or work, but seemed like that was the safer bet to Emily. Around 8:15, Emily says that she goes to get the pizza and brought it back to the conference room. When she put the pizza on the table, she said Matthew came towards her. She thought he was trying to grab a slice. Instead, he pushes himself onto her and kisses her. Since he was clearly drunk and her boss, Emily says she pushed him away and told him that they should get back to work. Emily then says that Matthew tried to kiss her again and kept trying to slip his hand underneath her skirt. He then unzipped his pants, exposed his genitals, and Emily screamed, "Matthew, what are you doing?" He then proceeded to masturbate in front of her as she ran out of the room crying and went home. And so these are the allegations that Emily has put in her criminal complaint. Again, this is entirely Emily's perspective. There's no input from anyone else. This is just what she is alleging in her criminal complaint. So now you have a copy of the criminal complaint and you are going to investigate what's inside of it. So you have developed a list of people that you think you need to interview based off of your brief conversation with Matthew. And Matthew tells you that you should talk to Steve's supervisor. And so on January 7th, 2 weeks, about 2 weeks after the incident, you meet with Steve's supervisor. Steve says that Matthew was with him the entire time they were at the holiday party. You asked Steve if he knew how much alcohol Matthew had consumed during the party. Steve says that Matthew only had 3 beers. Please remember that in her criminal complaint, Emily said that Matthew had 4 or more beers. So here's one important difference that you're gonna want to hold on to. Steve also says that Matthew was acting perfectly normal and not the slightest bit drunk. Again, in her criminal complaint, Emily said that Matthew was quite intoxicated. Steve says that he saw Emily drink at least 2 beers with Kathy coworker. That's important. You now have another witness to add to your investigation file of who you're going to want to interview. Another important thing about the statement is that in Emily's criminal complaint, she says she only had 1 beer, but now that is being disputed by Steve, who's saying she had at least 2 beers. Steve also confirms that Emily did approach Matthew twice. According to Steve, each time Emily approached Matthew, she leaned very closely and was whispering into Matthew's ear. Steve says because the bar was very loud, he could not hear anything Emily was saying to Matthew. And at that point, Emily was clinging on to Matthew. And shortly thereafter, Emily left the bar alone. After talking to Steve, you decide to meet with Kathy coworker regarding Emily's sexual assault allegations. Kathy tells you that she knew all about it and that Emily was quite devastated about what happened. You ask Kathy if she had spoken to Emily, and Kathy says that the Sunday after the holiday party, Kathy had brunch with Emily, and she urged Emily to report what happened to Human Resources. You ask Kathy to tell you what she observed that night, and Kathy tells you that Emily spent most of the holiday party by her side. She confirms that Emily approached Matthew twice and that Matthew was leaning closely towards Emily each time she went to talk to him. Kathy added that the second time Emily approached Matthew, she saw Matthew wrap his arm around Emily's waist. As Emily was walking away, he grabbed her hand and pulled her close to him. Kathy tells you that Matthew appeared to be saying something to Emily, but Kathy said she could not hear what he was saying since the bar was so loud. You asked Kathy if she saw Emily consume any alcohol, and Kathy tells you that Emily wasn't drinking that night because she had to go back to work after the party. So now you have 3 different stories about how much Emily was drinking. Emily says she had 1 beer, Steve says he saw her have 2, and Kathy's saying that Emily wasn't even drinking. Kathy adds that she saw Matthew and Steve drinking quite heavily and acting like they were in a frat house, which according to Kathy isn't different from how they act in the office. So that's a very important thing you're also going to want to hold on to, is when employees make that allegation that this is how they act in the office all the time, you might be concerned that you're going to have another employee bring a hostile work environment claim under Title VII, saying that this type of behavior is rampant in the workplace. So hold on to that phrasing at the end of that statement. The next person you meet with is Patricia President, and you ask Patricia if he remembered seeing Matthew or Emily at the holiday party. Patricia tells you that he spent the night making rounds and that he probably did talk to both of them at some point in the evening, but nothing about his interaction with either stands out to him. And so that's important, again, because you have Emily saying that she saw Matthew with Patricia, and Patricia told them to stay around for another round of beers. And so you now have a 5th witness in this incident, and they're giving you a very different story than any of the other witnesses you've talked to. And this is very consistent with what you see in a lot of investigations. As time passes, people's memories become a little foggy, and then sometimes people just don't want to admit to bad behavior. So in between Matthew giving the criminal complaint, you interviewing Steve and Kathy and Patricia, you try to contact Emily on January 2nd, 6th, 7th, and the 9th. You leave Emily a voicemail each time, but she never calls you back. During your interview with Kathy, you had asked her, you had told Kathy that you would love to talk to Emily about the allegations, and Kathy said she would relay the message to Emily. You also review all of the security footage from the internal and external cameras facing the front door. This is something that we rarely have. A lot of companies tend to not have their security footage for a very long time. Most of it resets within a week. Some reset within 24 hours and others reset in 30 days. If you have cameras in your facilities, this is definitely something you want to check. And you also want to make sure you check your policies regarding record retention and make sure that you're complying with those policies. Because if you have a policy in place that says you're supposed to keep that video or that data for 30 days, but you're deleting it after 7 days, you're going to have an issue in the long run. So make sure that if you're ever faced with a situation that you check your footage and you check your record retention policy to make sure that you're in compliance. So after you review your security footage, that you see that it shows Emily leaving the office and walking towards the elevators at 8:07 p.m. At 8:13, Emily is seen walking from the elevators through the front door with a box of pizza. At 8:22, Emily is seen leaving the office through the front doors. Although the footage does not clearly show whether she's crying, it does show that Emily is wiping her tears. The security footage does not show Matthew leaving that evening. He actually does not leave until the following morning at 7:20. Okay, so the last person you meet with is Matthew manager, and that's to get a statement from him. Matthew says that it's impossible that he did any of what Emily is accusing him of because around 8:10 p.m. he called his wife. Remember, Emily said she went downstairs at 8:07 and came back up by 8:13. So Matthew's saying he called his wife at 8:10. He said that he called so he could say goodnight to his daughter. He said that Emily must have come at the tail end of his conversation with his wife, during which he said that he was going to fire Emily if she didn't land this client. Matthew explained that Emily is only doing this because she knew he was going to fire her, which is why he assumed she quit. According to Matthew, on the day of the holiday party, he found out that Emily had not even started working on the presentation, even though she knew it was due on the following Monday. He offered to help her so she would not work all weekend. Matthew pulls out his phone and shows you his call log, which showed that Matthew had called his wife, Wendy, at 8:10 p.m., just like he said. He spoke to her for approximately 6 minutes and 14 seconds. So taking a step back, Emily says she came back up to the office around 8:13. If Matthew was on the phone with his wife, he would have been on the phone with her until about 8:16. So Emily probably did hear the tail end of that conversation. Matthew admits to having 2 beers while he was at the holiday party, but denied being intoxicated. You asked Matthew if he had a copy of the receipt from the bar. He said that he did, but it didn't accurately reflect how much he drank that night. Matthew explained that although he drank 2 beers, he also bought beers for Steve's supervisor and Patricia president. He added that 30 minutes before Emily left, he bought her and Kathy, coworker, a round of beers. And again, remember that Kathy said that Emily didn't drink anything at all, but here Matthew is saying that he bought everyone a round of beers, which included Emily and Kathy. You asked Matthew if he spoke to Emily while they were at the holiday party. He said yes, but that it was hard to hear her and hear what she was saying. According to Matthew, at one point during the conversation, Emily lost her balance and fell into him, so he grabbed Emily's arm to help her back up. Okay, Matthew says that Emily went back to the office without him, and by the time he returned, Emily had already ordered pizza and was waiting for it to be delivered. While she waited, Matthew went to his office to call his family. After he called, Matthew said he went to the conference room to get a slice of pizza. As Emily leaned over to hand him a plate, she bumped into one of the conference room chairs, lost her balance, and fell towards him. Matthew said he reached out to catch her. According to Matthew, he only briefly touched her forearms. Emily told Matthew that she was starting to feel ill and thought it would be best if she went home. According to Matthew, he offered to call her a cab, but Emily said she was fine. Matthew said that he stayed to work on the presentation and at some point in the evening fell asleep in his office. The following morning, he woke up and went home. So you've now interviewed all your witnesses. You decide to go meet with Patricia President to present the findings of your investigation and determine what you're going to ultimately do in this case. Since you were not able to corroborate any of Emily's allegations and Emily elected not to participate in the investigation, you allow Matthew to come back to work. You have issued him a written warning for returning to work after consuming multiple alcoholic beverages at the holiday party. You require Matthew to complete a supplemental sexual harassment training, and you reissue him a copy of your sexual harassment policy with an acknowledgement form. As a company, you decide that Save Financials will provide and pay for Matthew's legal counsel for his criminal charges. So those are the facts for this investigation. And now we're going to take those facts and apply it to the criminal justice system. So what happens now? So in Virginia, we have misdemeanors and felonies. And this is something that I think shocks a lot of people, is how misdemeanors are prosecuted in the Commonwealth of Virginia. So if there's two ways they can be prosecuted, and we're going to focus on the way it's prosecuted if it does not happen in the presence of a police officer. If it happened in the presence of a police officer, the process would be similar, but also very different, and it would change some of the outcome of how this case proceeds. So when an offense occurs outside of the presence of a police officer, you do not call the police department. If you were in Norfolk and someone stole something from your house, let's say someone stole a package off of your porch. If you called the police department and you saw the person who did it, the police isn't going to really do much for you because they did not observe it in their physical presence. If you saw the person and you knew who it was, you would actually go down to the magistrate's office and you would swear out a criminal complaint. The police department, and this varies by jurisdiction, is something to keep in mind. In jurisdictions where it's a smaller county, police officers tend to investigate a lot more matters. In smaller jurisdictions, in bigger jurisdictions, the same is not true. So if a victim goes down to the police department with a sexual assault allegation, the police department is actually going to redirect the victim to the magistrate's office. And this is different in felonies, but with a misdemeanor, the person who files the police report, but files the charges and prosecutes their own crime is the victim themselves. So the victim would go in front of the magistrate and they would essentially tell the magistrate everything that happened. There is no defendant, and the magistrate only gets the victim's side of the story. Based off of the victim's representations, the magistrate would either grant the warrant or not grant it. And probable cause is such a low threshold. It is not, when you think about it in the hierarchy of judicial thresholds. So to be convicted of an offense, it has to be beyond a reasonable doubt. That is all the way at the top. It is the highest standard to meet. Probable cause is at the bottom. It is the complete floor of standards that are utilized in the justice system. So it's a very easy hurdle to establish. It's as little as one person's word is enough to satisfy it. You don't even need any physical evidence. It's solely based off of what the victim is telling you. And based off of that, the magistrate would decide to issue a capias or summons. So a KPS is nothing more than just saying an arrest warrant. There are certain offenses in which you are not given a warrant of arrest. When the police go to serve the defendant, they may just give them a summons. And that really varies depending on what the individual is accused of and what their prior criminal history is. And if the person is served with an arrest warrant, when the police officer serves them, they will be arrested and taken back to the magistrate's office. They'll have a bond hearing from the magistrate, and then they'll have to post bond to be released. If you're given a summons, you're not going to be arrested that day. The police officer lets you go. You are on a bond, but the bond is for you to be on your good behavior. So that just means you can't commit any offenses while you're on bond. And I think that's something that a lot of people don't necessarily understand about the criminal justice system in Virginia. Most people that are charged with a misdemeanor do not get incarcerated. And whether or not you're going to get a warrant or a summons really depends on what your criminal history is for most misdemeanors. If you're someone who has a history, if the defendant, I should say, is someone who has a history of failing to appear in court, they're going to most likely be arrested and be kept on bond because the court's going to want to ensure that they're going to come to any future court dates. For the purposes of our fact pattern, we're just going to assume that Matthew has been a model citizen, has never been charged with any criminal offenses other than a couple traffic infractions. So he's going to be released on a summons. So after Matthew gets a copy of the summons, he's going to make his initial appearance in General District Court. And Virginia State Court has multiple levels in it. The bottom level, the first court, is General District Court. On that same level as Juvenile District Court, any misdemeanors are prosecuted in General District Court. You can appeal a conviction from General District Court to Circuit Court, and from there it can be appealed to the Court of Appeals, and then from there it can be appealed to the Supreme Court. So there's really 4 levels if you're charged with a misdemeanor. If you're charged with a felony, your case is not going to be prosecuted in General District Court. It will be prosecuted in Circuit Court. You will have a hearing in General District Court. It'll be a preliminary hearing. This is actually another probable cause hearing. So that's something that makes misdemeanors and felonies very different, is that in misdemeanors, you don't have a preliminary hearing, but for felonies, you do. So what happens at an initial appearance in General District Court for a misdemeanor is all the judge asks is, are you going to represent yourself, retain an attorney, or be interviewed to be represented by court-appointed counsel? And so in our fact pattern, the company has decided to retain an attorney for Matthew. And that's a conversation that companies really should be having, because the outcome of this criminal case can have legal liability for the company. And so after the initial appearance, a trial date is set about usually 3 to 4 months out. And again, this will be in General District Court. A lot of people think that you have a constitutional right to a jury. You do, but you really don't. And I know that sounds weird to say. For a misdemeanor, in General District Court, there is no jury trial. There is no jury box. You go into the courtroom, and it's like you're walking into the courtroom of Judge Judy or Judge Joe Brown. I don't know if that's a dated reference. It probably is at this point, but I hope you guys know what I mean. It is nothing more than 2 people standing at a bar, like a bench, and talking to the judge. A lot of courtrooms for General District Court don't have a witness box. There is not always a court reporter, because General District Court is a court not of record. So if you want a court reporter there, you have to go out and retain one. And a lot of people don't know that. So it's very different from what you see on TV. I think a lot of people's association with the criminal justice system is what they see on Law and Order SVU, and it's very different from how it actually operates in the real world. So Matthew's going to have a bench trial in front of a judge. If he's convicted, he can then appeal to circuit court and have a trial de novo. At that point, once you're in circuit court on appeal, you actually have a de novo means it's like the trial in general district court never happened. So once you've been convicted in general district court, you can appeal to circuit court and do the whole thing all over again. And any finding of previous guilt is like it never happened. It gets completely wiped clean. And at that point, you actually have a right to a jury trial. So let's talk about the different levels of misdemeanors. So felonies and misdemeanors both have classes. And another thing that makes a misdemeanor different from a felony is how much time you can be incarcerated with. Let's take the charge that Matthew has been charged with, sexual battery. In Virginia, that is a class 1 misdemeanor, which means that Matthew can be convicted for up to 12 months or confined for up to 12 months. So I know that sounds like I'm saying that Matthew's going to be serving 12 months in jail. That's absolutely not how it works, though. In Virginia, if you are of your good behavior for a misdemeanor, you only serve 50% of your time. So hypothetically, if Matthew were convicted of this offense, he could be sentenced to 12 months, but if he was on good behavior, he would only do 6 months in jail. So misdemeanors, you serve time in jail. Felonies, you serve time in prison / the Department of Corrections. And so that is how misdemeanor time works. On a felony, you would have to do, I think it's 75% of your time, which is drastically more than a misdemeanor. The other thing that makes a misdemeanor jail sentence different is that for a jail sentence, you have the capacity to do it on the weekends. And if you're charged with, I don't know, petty larceny, so a theft, let's say you stole something from Walmart, a judge could sentence you to 2 months in jail, but you could serve that entire 2 months on the weekend. In that instance, you would actually have to serve the entire 2 months. You would not get that credit for good behavior. And you have to think about it as like it's a balancing. You're getting the ability not to be confined Monday through Friday. So what you're giving up is that 50% half time. So that is how you serve jail for a misdemeanor. The other important thing to keep in mind about serving jail time for a misdemeanor is, in my personal experience, prosecuting these crimes, most judges sentence you with suspended time. So a judge will say, I'm sentencing you to 12 months in jail. Of that time, 8 months will be suspended. That 8 months is suspended, meaning you don't have to serve the remaining 8 months on the condition that you're of your good behavior, meaning that you're not going to commit any crimes. And during that time period, the person would only be incarcerated for 4 months. With good behavior, it's really only 2 months. And so that's how you'll see a lot of crimes sentenced. As you go through the different classes, you will start to see the amount of confinement and jail time go down. So for a class 2 misdemeanor, the most you could serve is 6 months. For a class 3 misdemeanor, it's just a fine. It's a fine of $500. And then for a class 4 misdemeanor, it's a fine of $250. So flipping it, let's say Matthew was charged with felonies. For a felony, it is very different. There are classes. Obviously, the highest class, the penalty is going to be death or life in prison. But sentencing someone for a felony is different in the respect that before you can even determine how much time someone is going to serve, you actually have to complete this worksheet called sentencing guidelines that take the aggregate of how courts across the Commonwealth sentence people, and they give you a guideline for how long this person should be sentenced for. And it's very dependent on the crime that someone is charged with. So let's say someone is charged with grand larceny, which is a theft of something that's $1,000 or more. And in that context, the court is going to look at, how is a judge, they're going to have in front of them how judges in, let's say, Fairfax, Richmond, Bedford County, how courts across the Commonwealth have sentenced people for that crime. It's going to give you a high end, a low end, and a midpoint. Usually judges sentence around the midpoint. For something like grand larceny, the low end could be as little as 3 months, and the high end is probably going to be like a year and a half. It's not something that has a high end. Something that would have a very high end would be like a burglary. So it also takes into account the severity of the crime. And so that's very different because for misdemeanors, there are no sentencing guidelines. Judges can sentence you to how much ever time they think is appropriate. They don't have to take into account sentencing guidelines. The other thing about felonies and misdemeanors, for a felony, there is no statute of limitations in a criminal case. You could prosecute something 20 years down the road. And that's kind of like obviously, you would hope so. We see that all the time with murders or old rape cases, people being prosecuted 20, 30 years down the road. For misdemeanors, it's very different. You can only prosecute someone 1 year within the time the offense was committed. So in this case, Emily went out and filed her criminal charges within days of it occurring. Had she not done that, though, she would forever be barred from pursuing Matthew criminally. The only exception to the 1 year rule is if the person's charged with petty larceny, which again is a theft offense. So I have examples here of misdemeanor offenses. Everything I listed in the fact pattern is a misdemeanor offense. So the most Matthew could ever do would be a year. But because he's charged with multiple misdemeanor offenses, he could in theory do way more than a year in jail. So I'm just going to go through the fact pattern and how the crimes are applicable here. So the first one we have is indecent exposure. That occurs when someone intentionally makes an obscene display or exposes their private parts in public. This is a class 1 misdemeanor. So the most Matthew could be punished for is 12 months of jail. The next one is, I went back. Oh, the next one is public masturbation. So typically indecent exposure and public masturbation get prosecuted together. This is something that employers should really be aware of because the criminal definition of public masturbation in Virginia includes something that's very important, which is when a person intentionally or obscenely engages in actual or explicitly simulated acts of masturbation while in a public place. You don't have to actually engage in the act itself. Sometimes you will see in civil lawsuits where you will have an employee make an obscene motion as if they are engaging in this act. And that can be problematic because the person who observed it can actually go out and file a criminal charge against them. They don't have to actually engage in it. It's just pretending to or making the gesture is actually sufficient enough under the statute to be convicted of it. The next one is simple assault. So an assault is an overt act intended to place a person in reasonable apprehension of bodily harm that creates a reasonable fear of apprehension. So think of this as, a lot of people think of assault as a physical touching. It's not. If I threw a pen at Leanna and I missed her, that is actually an assault. I've put her in reasonable fear that I'm going to throw a pen at her. In the context of our fact pattern, it's Matthew's actions about putting Emily in fear that she's going to be sexually assaulted, that he's going to touch her inappropriately. And again, that's also a class 1 misdemeanor. So now we have 3 class 1 misdemeanors that he's charged with. The next one is sexual battery. And so a lot of people aren't familiar with the term battery. Everyone uses the physical touching crime and they think of it as an assault. A battery, although it's not the best definition of it, think of battery as a completed assault. It is, I've now thrown a pen at Leanna and it's actually hit her. Something has actually made physical contact with her. So when you take that definition of battery and you apply it in the context of a sexual battery, it is any unwanted touching that has that is sexual in nature. the sexual in nature part is usually satisfied by someone touching the person's genitals or touching them. We've seen other cases where someone touches them with, I don't know, think of like a sexual object. That satisfies the sexual battery portion. So you now have, those are the offenses that Matthew has been charged with. All of them are class 1 misdemeanors. In theory, he's been charged with 5. He could actually do 5 years in jail. Is he really going to do that much time? Absolutely not. That's not really how the criminal justice system works. So in Virginia, because victims prosecute their own crimes, Emily goes to the magistrate's office and swears out her criminal complaint, which we talked about earlier. The magistrate gives a warrant of arrest, which Matthew's served with. The magistrate will determine if Matthew's going to get a KPS, which is arrest warrant, or if he's going to get a summons. Matthew then appears before a judge. He tells the judge that he is going to be retained by counsel. At this point, your company has decided to hire an attorney to represent Matthew because there could be legal repercussions for you down the road. And then the next portion of it is you've already done an investigation of everyone that was involved here. You've taken witness statements. So you're going to talk to your attorney and determine who should be subpoenaed for court. And with a subpoena, a lot of times employers, it's a tricky battle. If you subpoena witnesses and they don't want to come to court, what do you as an employer do? Can you force them to come to court? The answer with managers and supervisors is yes, you can. They are your supervisors and your managers, and you can tell them as an extension that they have to come to court. With employees that are not managers and supervisors, it's very tricky. And if you do it, it might come off as witness intimidation. And so that's a very delicate balance. You can't punish them or retaliate against them for not coming to court or not being compliant. The court can do that. The court can issue a show cause or a failure to appear warrant, but as an employer, you can't really do anything to retaliate against them. For anyone who's been sued civilly, the next step in the process you would immediately assume is discovery. So if you're sued under Title VII in federal court, you have the ability to depose the person who's accused you of sexual harassment or sex discrimination or age discrimination or whatever federal statute you're being sued under. You have ability to engage in discovery. And that discovery gives you depositions, you can request documents, you can do interrogatories, which are just questions that employees respond to. In state court for a criminal charge, the only discovery that the defendant is entitled to is any statements they made to police officers, which in this case is none because, again, police officers don't investigate misdemeanors, and their criminal record. That isn't very helpful. If you've been charged with a criminal offense, you know your own criminal record. You know whether or not you've been convicted of stuff in the past. Well, you would hope those people would know. And so you really get nothing. Really an interesting juxtaposition that in a civil case where the maximum penalty is money, you get all of this discovery, where in a criminal case, the maximum penalty is you could be incarcerated for a long period of time. You get no discovery. And so it's really just an interesting juxtaposition between the two. You would issue subpoenas, and this is the this is the statute for penalizing employees for appearance or service of court. I'm going to just breeze through this. So at this point, you've issued your subpoenas, you get no discovery, you then have a guilty plea or a bench trial. So here is why guilty pleas are so problematic. If you have an employee who does this without being represented by your company and they are approached, let's say there is a prosecutor involved, and they're approached by a prosecutor, and the prosecutor says to them, hey, I'll dismiss your charges. You just have to plead no contest. If you're of your good behavior for 2 years, we'll dismiss the charges, and it'll be on your record as though the case was dismissed against you. You never have to serve jail time. You never have to do anything. Most defendants are going to say, yes, I will take that plea deal. I will serve no jail time and it'll be dismissed against me. As a company, that can be a problem for you because under this code section, if the victim sues you civilly, they can use that against you to establish that the defendant was guilty, that the defendant admitted their guilt, and that establishes liability. This is why it's so important that if you have an employee that's been accused of any of these crimes, you make sure that they are represented. If you can have someone represent you and the company jointly, it gives you a stronger defense. If not, you will have an issue down the road with the Title VII lawsuit. So let's say in this case, your employee does not take it. They have a bench trial, most likely based on this fact pattern, the judge would find them not guilty. There's just too many discrepancies between all of the witnesses regarding what happened. Let's say, though, a judge did find them guilty. You'd have a sentencing hearing, and then you would have the ability to appeal to circuit court. And so I know we're at the 1 minute mark. I will just briefly touch on the civil causes of action in Virginia. So you had Matthew was charged with this criminal offense. There are also civil versions of these offenses. I'm just going to skip ahead. You can be sued civilly for assault, and you can be sued civilly for battery as a company. They don't have to sue Matthew. And the reason they get to the company is they will say that the assault and battery occurred in the scope and employment of the offense. So let's say you own a factory and you have someone who is a stalker, their whole job is to stock shelves for the company. And you have someone who is on a forklift. The forklift driver drives past them and the stalker touches them inappropriately as they're grabbing stuff off the shelf. The argument there is probably like the best example of how something happens in the scope of employment. Obviously, their job is not to commit sexual assault while they're in the workplace, but this employee, as they were stocking the shelf, touched someone inappropriately. It happened at the same time. To establish that something happened in the scope of employment, it's not enough for it to happen at your premise during work hours. They have to be actually engaging in their job duties. We see these most often in cases where it is a doctor who's performing some type of exam on a patient, or we see it in a case where it's a therapist who uses information to gain some advantage to commit a sexual assault. Those are the most common examples, but we do see them in everyday workplaces. And a lot of times it is a manager who uses their position of power to coerce an employee to perform some sexual act on them, which is why it's so important to make sure you are training your managers and your supervisors on your policies and having policies that prohibit this type of conduct. The other civil offense that someone can sue you for is intentional infliction of emotional distress. And this is just that someone is so distraught by what happened to them, they now have severe distress as a result of it. So if you're an employer that's subject to Title VII, you know that there are caps on damages for compensatory and punitive damages. If you have less than a certain number of employees, you're going to be subject to the 50 employer cap. If you have less than 100 employees, you're going to be subject to 100,000 cap. That is not how it works under Virginia state law claims. There is no cap on compensatory damages. You can get a jury award or just any award, even if it's from a judge, that is $1 million. You're never going to get that in a Title VII lawsuit, but you can get it for a state cause of action. There is a cap on punitive damages, and in Virginia, it's $350,000. So if you have an employee who establishes that the sexual assault occurred in the scope of their employment, you're going to have a more serious damages outcome than you would under Title VII. And the reason these lawsuits are so much scarier for employers is because Title VII is going to be brought in federal court. In federal court, you have the opportunity to do a motion to dismiss at the outset and have Title VII claims dismissed if they're not pled sufficiently. It is so much harder to have a case dismissed in state court on a demurrer, which is the state court version of a motion to dismiss, than it is in federal court. It is rarely granted. In federal court, they're routinely granted. Then, If your case in federal court doesn't go away, you then have the opportunity to do a motion for summary judgment, which is essentially like a dry run on paper for a trial. You write a motion, you state all of the facts supporting your side, saying that this didn't happen, there's not enough evidence to establish this, and a jury could never find that the plaintiff could be awarded. You attach exhibits and affidavits to support your side. In federal court, these are routinely granted. You can use deposition transcripts. In state court, you cannot use any of those things. You can't use transcripts from depositions. You can't use affidavits and declarations. So they are never granted. It is so hard to have a motion for summary judgment granted in state court. So in federal court, your attorney costs and fees are going to be lower because you're able to resolve this a lot faster. In state court, you're now looking at something that's probably going to go in front of a jury. What makes federal court also more advantageous is that in federal court, most judges require you to have a settlement conference. And our local magistrates, federal magistrates, are fantastic. Some of their rates of settlement on cases are 90%. They're able to settle 90% of their cases, which means you're not going to be going to a jury trial and this matter will be resolved. In state court, we do not have that same requirement. There is no requirement that you settle or try to resolve it. And so again, you're more likely to be faced in front of a jury. The makeup pool of juries in state court versus federal court are also not as great as well. Your jury pool is going to be, for lack of a better way of describing it, if you look at the Virginian pilot, you'll often see a lot of times that people do not report to jury duty in the city of Norfolk. And a lot of cities have a really hard time getting people to show up to jury trials. And so that makes it even more difficult for you to fill a jury, convince them of your side of the story, because you're at this point going to have a lot of people who don't even want to be there. And so state court is not the preferred place to be, from defending these cases to the cost of defense to the civil penalties that can be imposed against you.
Elena, we are just about running out of time, and I'm afraid that the Zoom is going to cut off on us. So if we can just spend another minute to just wrap it up. This has been fascinating, and I'm dying to figure out what happened to Emily. But yeah, if we can just wrap it up, and this has been wonderful. Thank you.
Yes, I will finish off on this note. Prior to this past year, a lot of employers were not subject to the Virginia Human Rights Act. They were only subject to Title VII, and that was their only concern. Effective July 1st, the Virginia Human Rights Act changed its definition of employer, so now applies to 15 or more employees. Prior to that, it was 15 or less employees. So you may be an employer who was subject to Title VII before and never had to worry about the Virginia Human Rights Act. That is now not the case. You should be concerned about the Virginia Human Rights Act. If you have not done so already, please look at your employee handbook. Please make sure that you update it and start training on it. This entire presentation is just to reinforce those two things, is to make sure that you have a policy in place, that you're training on it, and that you have employees in the HR department or someone in management who can effectively do an investigation. Because if you aren't able to do an investigation effectively, you have waived your two most important defenses under Title VII in the Virginia Human Rights Act, which is called the Fairgood-Ellerth defense, which is, it comes down to this. You have a policy in place, you investigated it, and you did it effectively and efficiently. If you did not have a policy in place and you did not investigate it, you have waived that defense. If you hadn't waived it, you have the ability to have your case dismissed against you. But if you don't have a policy and you didn't investigate it, it's almost a per se admission that the statute has been violated. So you don't want to be in that situation. And so
Michelle is reminding us all in the chat that if anybody needs help with surveillance cameras or communications on that level, please check out South Bay, because they can help your company with that.
Yeah. So just to wrap up, make sure that everyone has a good policy in place and is training on it. Because in this case, if this case went on appeal, if this case if it was your company and you were sued, a court would likely determine that you are not liable under Title VII or Virginia Human Rights Act because you did an investigation, you had a policy in place, but you will have issues under for civil causes of action of assault and battery and intentional infliction of emotional distress. So although you win some, you don't win the entire case. That's all. Thank you, everyone. I'm sorry for going over.
Oh, Melina, thank you so much. This was wonderful and very well told, and really just, pulled us all in with all the information. So thank you very much. Thank you, Michelle from South Bay, for being our sponsor. And again, reminding us that if you need help with surveillance for these sorts of things, absolutely check Michelle at South Bay. Also, thank you to Dream Vacations. Let's pack and go. I think we're all ready to do that. Our next HRSHRM session will be Wednesday, December 2nd. It's 80 degrees in February. Do you know where your employee is? How to manage chronic leave issues in the workplace. So, we don't want to blame Dream Vacations for our people taking off, but we'll work that all out. So that's December 2nd. And again, thank you to South Bay and Dream Vacations. And Melina, thank you very much for that wonderful presentation. If anybody has any questions, no one put any questions into the Q&A or the chat. But if you do have any questions, please get them to Liana and she can get them to Melina, and we'll make sure that we get some answers to you. Thank you all for being part of this HRSHRM Hampton Roads Chamber event. Thank you.